Hi, this is Sean with the Palmer Law Firm. We're all in a very stressful and fearful time with the outbreak of the COVID-19 virus, and it's changing the way we live our lives. Many people are being sent home from jobs or limited in their interaction in large groups. For our children, schools are closing and many normal extracurricular activities are being stopped. To stop the spread of this highly infectious disease, we're being told to practice social distancing. That means staying away from other people and especially in large groups. But what about families with custody orders? To date, there's been no real clear message about how families should address this, and for families who already find themselves in high conflict custody arrangements, the strain will be tremendous and the path confusing. Should periods of visitation from non-primary custodial parents be discontinued with all this social distancing going on? That's a big question a lot of people have. And what will be the repercussions if I keep my child from the other parent, and how can I avoid those repercussions? Here are some clear answers to those questions. Number one, don't deny visitation to the other parent unless you have a very good reason to do so. If you are the primary caregiver and the other parent has periodic visitations, you may be tempted to deny the other parent their weekend visitation during this crisis out of just general fear that your child may become infected at the other parent's house. But before you unilaterally disregard the custody order, you should carefully consider whether you have any real reason to do so. The consequences of violating the custody order may be very real and land you in some real trouble with the courts. Our Harris and Galveston County judges take a dim view of people violating their orders, especially if the reasons are vague and ambiguous. Even if you are well-intentioned, you could get in trouble. Denying visits may result in severe consequences for you and may give cause for the change of primary custody to the other parent in some extreme cases, and even jail sentences in some very extreme cases. Number two, communicate with the other parent and find common ground for decisions. Before you decide on your own to deny visitation with the other parent, first communicate with them about your fears and try to come up with an agreement about temporary modifications to your visitation schedule. You may find that they share the same fears about your child being at home. If your co-parenting has been high conflict up to this point, however, you might find this very difficult, but you've got to put your best effort forward. Even if you've had difficulty in the past communicating, both parents should try to put that aside right now, at least until this crisis has passed. And one of the best ways to handle that situation is to adopt a very businesslike and professional attitude towards these issues at hand. Try to be focused and avoid emotional reactions. Tell the other parent exactly what you want to talk about when you call them and stick to that only. If they try to bring up the past or get off topic, and remind them of the urgency and importance of coming to an agreement on how to handle the visits during this crisis. You both have different viewpoints of what is the best to take action for the children and keeping your children safe, but they are honest differences. With so many conflicting messages on social media and the mainstream news, it's not surprising that you might have different ideas about what's the best interest for your child. The most important thing is to be consistent between the two parents. This situation is like no other, and very likely it wasn't thought about when you had your original divorce or custody order fashioned. You may be called upon now to make decisions that are outside the order. Try to find a neutral and reliable source of information for any tiebreakers you might have regarding how you should deal with things. Try to agree on one source for recommendations for your child's safety, and agree that you'll both use that source for co-parenting decisions that are not covered in your court order. You may agree to follow the advice of the child's pediatrician for guidance, for instance. This is especially important if your child is immunocompromised or has any other underlying health condition. Or you could both agree to follow the latest recommendations found on the CDC's website or the Texas Health and Human Services website. But whatever source you decide on, it's important that you both avoid the added conflict and stress of disagreement, and you should find as much common ground as possible. One good start in finding common ground may be in that you both express your fears for your child and reaffirm that you each love your child and have the best interest for your child at heart. 3, think of creative solutions. What solutions could you come up with that would satisfy each of your concerns about infection and health versus the legitimate right and need of the child to have contact with both parents. If infection is a legitimate concern, such as if one parent has been exposed to an infected individual, it is possible to agree to on temporary basis to have visits outdoors, agree to maybe a recommended distance between the child, perhaps playing catch or kickball or similar activities, something where you're separate but together if at all possible. This may sound kind of outlandish, but in these difficult times, we have to deal with unusual circumstances. Maybe, of course, the parents can FaceTime or increase their FaceTime that they've already had. Can you agree with the other parent? You'll have additional periods of time with the child to make up for time that was lost during this crisis, after the crisis is over, and it will be over. Number 4, whatever agreements you do, I recommend that you get them in writing and make sure that each parent has a signed copy. Getting things notarized right now is a bit of a challenge, so you can at least get it down in writing and sign it. A signed agreement can be used in court to defend yourself if the other parent claims you've unilaterally violated the order. Number 5, if you can't come to an agreement, you're going to have to file a modification request with the court. If you legitimately believe that the child is at an increased risk of infection, if they are allowed visits with the other parent, and you can't agree with the other parent on a modification of the custody agreement, then you must consider filing a motion to modify the parent-child relationship and request emergency temporary orders to discontinue the visits. If you don't do this, you run a high risk of being held in contempt of court for denying the other parent's court-appointed visitation. You'll have to execute and attach an affidavit that shows a significant impairment, which details why you believe the physical contact with the other parent would endanger the child. The standard on getting such an emergency temporary order, however, is very high in the best of times. Generally, general fears or undefined fears will not be sufficient. You'll have to have some really compelling reasons for the judge to believe that the visits with the other parent will significantly impair the child's health. Reasons that may be warranted, if proven, could be things like the other parent had close contact with someone who's diagnosed with COVID-19, or the other parent recently traveled to Italy or China, or the other parent attended a high exposure conference or situation prior to the social distancing orders that are going around. And or perhaps the other parent may have had contact with someone infected with COVID-19 and your child is compromised with immunocompromised disease or other underlying health conditions. Agreements are like a vaccine, really, when you think about it. They're a vaccine against family conflict. So try to get those agreements each and every time that you can, because it's the best line of defense against the harm that will come to your children as a result of parental disputes, which is an additional thing. We don't need to put our children at risk. If agreements are ineffective or unavailable, then ultimately you may have to call an experienced family law attorney. If you have any questions, you can contact us at the PALMER Family Law, and we can encourage you to schedule a free call with one of our family lawyers. And we are leveraging our technology with our online client portal, electronic forms, e-signature documents, and other capacities to minimize your need to make trips to our office. And so we should all be practicing the social distancing right now. And so I encourage you to resolve these issues outside of court as much as you can. And if not, give a call to one of our attorneys and we'll try to assist. Thank you very much.